And Mr. Williams, in cause number 25 DCCR 0985, is charged with capital murder. And Mr. Cashin has filed a motion asking that I reduce bond. We were here either last week or the week before. Reset this case today to give everybody some time to get prepared on that motion. And Mr. Cashin, do you intend to call your client?
No, ma'am.
Okay, you may call your first witness.
Okay, but before I do that, Your Honor, I know some of these proceedings are streaming, and one of my witnesses is going to testify. Can she refrain from using her specific address?
Absolutely. I don't typically require any, just Jefferson County is fine.
Jefferson County, yes.
Yes, sir.
Yes,
Absolutely.
sir.
We don't need specific addresses ever,
That's what I
or very rarely from
Okay.
especially a witness.
Okay, all right. I'd like to call Angel Anderson.
Ms. Anderson? And Mr. Williams, if you'll just kind of step around closer to Mr. Cashin, kind of right there. You're good right there, sir. And maybe you can come right up here in the front, please. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
Thank you. Will you please state your name for the record?
Angel Anderson.
Ms. Anderson, where do you currently reside?
Beaumont, Texas.
Okay, and how long have you lived in Beaumont, Texas?
For 43 years.
And do you know the gentleman to your left?
Yes.
And what is his name?
Larry.
And what
Ma'am, can you speak up so that I need to hear you and the court reporter needs to hear you as well, please? Thank you.
and what is your relationship to Mr. Williams?
That's my brother.
So you've known him all of your life.
All my life.
And does he currently reside here in Beaumont?
Yes.
Okay, are you currently employed?
Yes.
And what do you do, ma'am?
I have a business.
What kind of business?
I have a hair store.
Okay, and that's here in Beaumont?
Yes, sir.
Okay, and how long have you been the owner of that business?
For 6 years.
Okay, and so Mr. Williams, prior to him being arrested, was he working?
Yes.
And how long had he been working?
I don't know.
And what had he been doing? What type of work?
Landscaping.
Okay, and he, have you ever, do you know what a bond process is?
Yes, sir.
And you know what a bond consists of?
Yes.
And you have to go to a bondsman, correct?
Yes, sir.
And the bondsman wants to be assured of what things?
There was like a co-signer, financial,
And some
and
collateral.
collateral.
Okay. And do you and your family and friends have enough money to post a bond like in the amount of maybe like $50,000?
Yes, sir.
And presently he has a bond that's approximately $10 million. Is that right?
Yes, sir.
And have you all attempted to make that $10 million bond?
No, sir.
And the $10 million bond, that was set by a magistrate like early on in this process?
Yes, sir.
And also his other bond for the aggravated assault case was raised. Is that correct?
Yes, sir.
From what to what?
25,000, if I'm not mistaken, to 100,000.
To 100,000?
Yes, sir.
Okay, so he has approximately $10,100,000 worth of bond. Okay, and if the judge sees fit to place his bond like at maybe $50,000, do you have family, friends to put up the property like collateral as well as money in order to secure the bond?
Yes.
Would you be willing to co-sign on the bond?
Yes.
Do you have other family members that would be willing to co-sign on the bond?
Yes.
Have you been in touch with the bondsman, and do you know of a bondsman that would be willing to go along with the bond for you?
Yes, it's in good standings with his bond.
I'm sorry, I can't hear you.
Yes, ma'am. He in good standings with his bond he had approved.
Okay, so
I still didn't understand what you said at the end.
He in good standings with the.
Oh, he's in good standing. Okay.
Yes, ma'am.
okay. Have you ever known Larry not to appear in court?
No, sir.
And he has on the other bond that he had for the aggravated assault, did he ever fail, to your knowledge, to come to court
No, sir, he already came.
He always came to
Yes.
court every time,
Yes.
on time. There was never any problem with him showing up in court.
No, sir, there's no problem.
All right, and I passed the witness.
All right, thank you, Mr. Cashin. Mr. Smith, any questions of
No
this witness?
questions, Judge.
Thank you, ma'am. You can go back and have a seat. Any other witnesses, Mr. Cashin?
No, ma'am, but Your Honor, I would like to point out that there are other family members in the courtroom
Yes,
that
sir.
are of adult age. Tanisha Williams, his daughter, who is present in the courtroom, she would say the same thing that Ms. Anderson just said, as well as his daughter, Laridra Clay, who's also an adult, and she would say the same things and would confirm with what Ms. Angel just now said.
Thank you.
Presently, his bond, which I feel is
Mr. Williams, you can step back around, sir.
Presently, his bond, which I feel was emotionally set at $10 million. I think that is very excessive and is very punitive. And Mr. Williams, although he has had some issues with the courts and the judicial system, he has never, ever failed to appear in court. And I think that because of, I think that his prior attendance in court, his prior taking care of all of his court business shows that he is not ready to flee, he's not ready to run, that he will come to court and face the charges and face whatever the court requires of him. A monitor would be sufficient to maintain his location, like with the GPS. He does need to work, so I would not like to request that he be placed under house arrest, but I think he should be able to have maybe a monitor or maybe some curfew hours as opposed to a $10 million bond. I think a reasonable bond for a case like this should be about $50,000, and I would like to request that the court set his bond at $50,000.
Okay. Mr. Smith?
Judge, the state is opposed to a reduction in the bond. This capital murder is based on the fact that we were coming up for trial. The murder of the victim, who was also the victim in the aggravated assault, occurred very shortly before that was actually going to be called for trial. And the fact that he fled after committing this murder to Houston and had to be located in Houston shows that he is likely to run if given a bond. The family of the victim is also in fear for their lives should he get out of jail, and we'll be ready to proceed to trial as soon as Mr. Cashin is up and ready.
Your Honor, in regards to what Mr. Smith just said, Mr. Williams, when he was located in Houston, was on his way to my office. And that's the reason he was in and around the Houston area, because he was coming to my office to consult with me because he had heard on the news reports about this alleged murder, and so he was coming to talk to me, and he was not in the process of fleeing, but he was in the process of coming to consult with me about the situation. So I think that by alluding to the fact that he was arrested in Houston is like kind of a stretch, because he was attempting to meet me at the office.
All right, so obviously this case is the date of this case precedes any modifications that happened in our legislation this last cycle that have come into law as of yesterday. One of those is actually that it is appropriate, and if someone is out on a bond for a felony offense and the allegations are that they commit another felony offense, to have no bond, which is something that is more strict instead of more lenient with regard to bonds. I believe the fact that Mr. Williams has come to court when required obviously is nice and great, but the fact that he's the allegations are that, and if they're allegations, he hasn't been found guilty, but I am entitled to take into consideration the underlying facts of the case. And so based on the the offense that he was charged with initially, the aggravated assault, based on the fact that this new allegation is that the victim or the complaining witness in that case is now the victim in this alleged case. I do not find that it would be in the best interest of our community to grant the motion.